Would any of you advise a client to defy a federal court order?
No.
None of you would? How about you, Professor?
I mean, under most circumstances, we follow the government and private parties follow court orders. I suppose I would not rule out ever the possibility that in a sufficiently egregious order, there should be some consideration of whether there's a way.
So in some cases,
I think it's a qualified answer, yes.
In some cases you would.
In an extremely narrow band of cases, I think it would be considered, yes.
Okay. Do any of you think that nationwide or universal injunctions are not being abused?
I'm not sure if I may, Senator, I'm not sure what the time horizon of the question is. I don't think that there could be good faith disagreements about the correctness of some of them, but I have not seen in the last 4 months abuse. No.
I've read your stuff and I've read your writings. I don't want to get bogged down with this, but I have little respect for your opinion because I've read your stuff. When someone is in the White House that you agree with and someone gets a universal injunction against him, you don't like universal injunctions. You called them judges acting like they're politicians in robes and judges looking like crass political actors. But now that President Trump's in the White House, who you dislike, you think that universal injunctions taste like pumpkin pie. So I have to discount what you say because I think you act on your political beliefs. And I worry that that's what you're teaching your kids. So I'll leave you out of that. Do you think nationwide injunctions are being abused?
Certainly, Senator. I think that is.
They're being abused by both sides, aren't they?
Yes, Senator.
Both Republicans and Democrats are forum shopping, aren't they?
Certainly.
Professor, do you disagree with that?
I think both sides are abusing them. I agree.
Okay. Both sides.
Yeah.
There are no clean hands here. Now, your suggestion is that when a federal judge issues a nationwide injunction, there should be an automatic stay and an expedited right of appeal. Is that right?
Yes, sir.
Do you disagree with that?
I haven't given enough thought to have a position on it, Senator.
I suspect, Professor, your answer will be it depends on who's president.
No, Senator.
Let me ask you about this. What if we had a rule? I was reading an article the other day. I'm not suggesting it. I just want your opinions. That said, if a president, any president, issues an executive order, let's say, that clearly violates settled Supreme Court precedent, that a federal judge can't issue a nationwide injunction. For example, if a federal a president issued an order that said no one in America has right to counsel any longer, including but not limited to, in a felony case, having the government pay for your lawyer if you can't afford it. That clearly violates settled Gideon v. Wainwright. In that case, a judge has no authority or does have authority to issue a nationwide injunction. But in a case where the law is unclear, a judge should refrain from that. Now, obviously, we'd have to trust our judges, but we're supposed to be able to trust them anyway. What do you think about that?
I don't agree with that, Senator, because I think universal injunctions transgress the limitations under Article 3, even if the underlying merits are clear.
I happen to agree with you. I don't think there's any basis under Article 3, under Supreme Court precedent, under the English common law for nationwide injunctions. I think politicians have helped judges, and many judges are politicians, to just make it up. And many of them are like Professor Shaw here. If they like the president, they're against nationwide injunctions. If they don't like the president, they're for him. Professor, let me ask you this while I have you. On April 22nd, 2024, you said there are some members of the Supreme Court that are evil. Which justices were you talking about?
I'll take your word, Senator. I don't recall using that word, but...
All right, here's what you said. You were talking about the majority opinion in Muldrow v. City of St. Louis. You said, quote, Justice Kagan, will she be able to control the opinion's future distortion by her evil colleagues? Probably not, end quote. Who were you talking about?
Sir, I'm very skeptical. If it's a transcription, it was probably a transcription error. I do not think I said...
No, you said it. Once you own up to it, which you call some of the members of the Supreme Court evil. Now, which ones do you think are evil?
I would have to refresh my recollection. I've been very critical of some members of the Supreme Court.
You made that statement, aren't you?
I'm
you're an officer
Senator, it doesn't
of the court.
Sound like something that
you know
I would
what I'm
say.
Embarrassed at that you're teaching our kids.
I don't refer to Supreme Court justices as evil in the classroom,
on
sir.
Your podcast, April 22nd, 2024.
Okay, well,
big as Dallas. And you're an officer of the court, and you're here advising us to be respectful to federal judges, and you say they're evil members of the United States Supreme Court? Gag me with a spoon. You're part of what's the problem in all of this.
What's really going on in this exchange isn't just a personality clash. It's a deeper argument about how much power courts should hold, how evenly that power is applied, and whether the legal system is starting to feel more political than principled. The discussion opens with a simple question. Would a lawyer ever tell a client to ignore a federal court order? Almost everyone agrees the answer is no. That point matters because following court orders is a basic pillar of the rule of law. Once people start picking and choosing which rulings to obey, the system breaks down. But things get more complicated when one witness adds a narrow exception. She says that while court orders should nearly always be followed, there could be extremely rare cases where an order is so clearly unconstitutional that lawyers must carefully consider their response. This isn't support for defiance. It reflects a long-running legal debate about what happens when government authority collides with fundamental rights. From there, the conversation turns to nationwide injunctions. These are rulings where a single federal judge blocks a law or executive action for the entire country. They were once uncommon, but today they are used regularly against presidents from both parties. Several witnesses make an important admission. This isn't a partisan issue. Republicans and Democrats both engage in forum shopping, filing cases in courts they think will rule their way. That changes the frame. The problem isn't just about certain judges or certain cases. It's about a system that lets one judge pause national policy. That's where public frustration grows. When policies live or die based on which courtroom hears the case, courts can start to look political. Even if judges are acting honestly, that perception alone can damage trust in the judiciary. The hearing then asks whether reforms are necessary. One idea is to automatically pause nationwide injunctions and speed up appeals so higher courts can rule quickly. Supporters say this would limit judicial overreach without taking away courts' ability to stop unconstitutional actions. Some witnesses go even further, arguing that nationwide injunctions may exceed what courts are allowed to do under the Constitution, no matter how strong a case appears. From that perspective, even well-meaning rulings can disrupt the balance between branches of government. Tension increases when the focus shifts from legal theory to credibility. A professor is pressed about past statements on the courts and accused of shifting positions depending on which party holds the White House. Whether fair or not, the moment highlights a serious concern. When legal arguments seem to move with politics, it becomes harder for the public to view courts as neutral. That concern grows when comments about Supreme Court justices are brought up. The issue isn't criticizing decisions. That's normal and healthy. The question is how far rhetoric should go. Personal attacks on judges can weaken confidence in the institution, especially when they come from legal scholars who influence future lawyers. Zooming out, this exchange shows why court debates have become so intense. Nationwide injunctions, executive power, and judicial rhetoric are all linked. Together, they reveal a system under strain, where legal tools are increasingly used to achieve political goals. Still, there is common ground beneath the conflict. Everyone agrees court orders usually must be followed. Everyone admits nationwide injunctions are now used strategically by both sides. And everyone understands that public trust in the judiciary is fragile. The big question remains unresolved. How do you fix the system without creating new problems? Should Congress step in? Should judges show more restraint? Or should higher courts move faster to settle major disputes? Reasonable people disagree, but the conversation itself matters. If this exchange grabbed your attention, it's because it touches a core issue. Who gets to decide national policy, and how quickly can those decisions be challenged? These aren't abstract debates. They shape real outcomes that affect millions. If this breakdown helped you understand what you just watched, like the video so more people can find it. Share it with someone interested in how the courts really work. And subscribe for more clear, context-driven analysis.